Thank you very much. Okay. Thank you very much, everyone. Welcome to the late morning session, and thank you, Peter. My name is Rob Silvers. I'm a partner at the law firm Paul Hastings, based in Washington, D.C. And our panel now is going to focus on the role of corporations, of the business community, in artificial intelligence and the governance of artificial intelligence from the corporate perspective. The role of the corporation is so central in every way that we speak about AI and our society. People are going to enjoy the benefits of AI largely through the products and services that are offered by companies. And likewise, people are going to feel the consequences that come from widespread AI deployment through the products and services that are offered by companies. And so many aspects of AI now are described in superlatives. The CEO of a major tech company recently compared the importance of the advent of AI to the invention of fire, or the human ability to harness fire. The benefits of AI, whether in healthcare, financial services, governance of our society and our societal order, are described as transformative and breathtaking. Likewise, the potential risks are described in literally apocalyptic terms. And superlative amounts of capital and human talent and data and educational resources and focus are going in support of AI right now. And given the role of companies behind all this, I don't think it's an exaggeration to say that the way that companies decide to govern their development and deployment of artificial intelligence, or the ways that our laws eventually require those roles to be governed, are going to have a literally transformative effect on humanity and on our society. And so we want to talk about that. We want to talk about that landscape with our panel. And let me make some brief introductions to our excellent panel. First, to my immediate left, we have Terrell McSweeney. Terrell is a partner at the law firm Covington & Burling and is a former commissioner of the Federal Trade Commission. Terrell has deep expertise in a variety of regulatory contexts that are highly relevant to the field of AI, whether that be competition laws, data protection laws, unfair trade practices, regulation, and the like. To Terrell's left, we're joined by Pedro Pavon. Pedro is managing counsel at Oracle. He manages a substantial team of attorneys covering data licensing, artificial intelligence and machine learning, blockchain, as well as privacy and cybersecurity risk. Pedro also had former senior roles at the U.S. Department of Justice and in the U.S. Army. To Pedro's left, we're joined by Mike Phillips of Microsoft. Mike is Assistant General Counsel at Microsoft for the Artificial Intelligence and Research Group. He is responsible for providing legal and compliance support to Microsoft's AI products organization and to the Microsoft Research AI team. And finally, to the far left is Jeff Ward. We're very pleased to have Jeff join us. He is the director of Duke University's Center on Law and Technology. Jeff oversees the Duke Law Technology Lab, which is an accelerator for legal tech companies, and he focuses his scholarship on the law and policy of emerging technologies, including, of course, artificial intelligence. And if we're talking about the role of the corporation, of business, in artificial intelligence, I think literally we could not assemble a more significant and representative panel than this one. We have in-house counsel from two of the companies that are literally leading the charge globally on artificial intelligence. We have a former senior regulator in the space that in the US will, if any regulator at this point comes to assume a role over the governance and enforcement of fair play in the AI space, it is likely to be the Federal Trade Commission. And we have a leading academic who focuses on critical questions around the intersection of law and technology. And so we really are very pleased to have this group. And let's jump right in. I want to start with Pedro and Mike. I want to start right from the corporate perspective. We know now that AI is being driven forward by companies primarily. That's where there are some sort of nonprofit efforts underway, but when AI is hitting the market right now, it's coming out of companies. So we'd like to start with your perspective. Can you share with the group how your global companies organize themselves around AI development and importantly around AI governance and consideration of ethics, legal compliance, and the like?
You want to go first?
I'll allow you.
I get the A.
Is that the way it's right?
Yeah, no, it's a fantastic question. It's an honor to be able to actually share some of this thinking and frankly, what we consider to be a very evolving approach. You know, the one of the values we get out of having these sorts of conversations is that we learn a lot from others in the industry. We learn from people who have regulatory backgrounds and academic backgrounds and the like. And it really informs how we continue to develop out our thinking on these sorts of issues. So to your question, Rob, we are today continuing to build out what we would describe as this muscle for operationalizing these sorts of issues. And it consists of a number of things. There certainly continues to be, as your question suggests, a development-driven approach to thinking about what it means to do AI technology responsibly, what it means to address ethical issues, how and when to bring those to bear. But it's done, I think, in a more traditional fashion in the sense that we think about what it is that we want to build. We think about how we build services and technologies, how we've done that for years and handled a variety of issues. And we start to think about how can we adapt that now to encompass and think through all of these new sorts of considerations, which for many of us really extend beyond what we're used to dealing with. I think folks who've worked in software development can talk to you about where they were with respect to security 10 or more years ago, or how we've evolved our approach to data handling and privacy and how we've learned through that. And so as we're tackling this now, we're sort of going from what we know, which is how we've built those sorts of systems for evolving our development practices to accommodate novel issues. And we're now looking at this AI space as sort of taking all of that experience and really blowing it up to exponential levels, given the breadth of the sorts of issues that we're now covering. So in simple terms, what we've looked at is, okay, what do we have in place today, and now how do we begin to grow the expertise? How do we then begin to operationalize and put into place the sorts of steps and things that we would need to do? Is just one example of many, because I think it's a topic that rightfully comes up and has throughout the sessions today. How do you think about an issue like the introduction of bias into AI systems? This is not something that I think many who have done traditional software and service development or who've counseled those sorts of practices would necessarily consider themselves experts in. And so how do we begin to learn and move? And so we bring in people who have research backgrounds. We bring in people who, from the outside, who have more of an ethical background or perspective. We certainly bring in the lawyers, we bring in the PR folks, and we bring in the developers, and we get together and think through how to work this out. That then starts to evolve into principles that we seek to crystallize and operationalize. And then we do a lot of what people have talked about in terms of sandboxing and trialing. I think necessarily as a first ingredient to getting into this space, there has to be this level of humility, this recognition that we're not going to have good, clean answers and we're not going to have good, clean processes out of the gate. And so we're very much looking at this as an area where we want to experiment. We want to fail fast, if you will. I know that's kind of become a buzz term, but it has application here, in that we want to get into these new issues and play with them and work through them and begin to crystallize and move that toward operationalizing.
Yeah, I mean, I don't have much to add. I agree generally with everything you said. I'd say what's interesting and unique to this AI phenomenon, I think from an industry, corporate standpoint, is that the discovery phase, the development phase, and the discussion phase are all happening at the same time and at lightning speed. And what's driving that is how quickly the technologists, the research folks are innovating in the area, right? And so we're having all of these discussions in real time about real research that's ongoing and making it to the shelf, becoming a product or a service pretty quickly. And I agree that you have to do all of these things at once. There's a lot of risk involved with that. Companies are across industries are trying to figure out how to manage that risk appropriately, not just for themselves and to protect the company, but also to protect the public. And I think you're right. There's a lot of interest and a lot of discussion inside technology companies, but I see it across industries to try to ensure that at least we're being thoughtful about how we go to market with products and services that incorporate AI. What's interesting as well is the fact that the technology we're talking about is not really new. Machine learning principles and the math behind the most of these products has been around for a very long time. What's changed is the compute power and storage capacity have multiplied exponentially in the last couple of years, enabling all of this development to take on. So when you compile the fact that the theoretical part of this has been around a while, and now we're not really, I used the word discovery when I started speaking, we're not so much in the discovery phase as we really are in the implementation phase of AI and machine learning, given the fact that a lot of the theoretical components of what's going to market now has been around for a long time. So compile that whole mess into one container, and what you get is a lot of heat, a lot of tension, a little bit of confusion, and a lot of really smart people trying to figure out how to make it work and not cause harm.
And Mike and Pedro, you both work in very mature, large organizations that are well resourced, and you've spoken of these frameworks for different stakeholders within the companies who weigh in. Have these frameworks? Were they designed and dictated centrally and people fell into line, or is it a more organic process? Because a lot of companies that are maybe not as developed but are racing ahead with AI development and deployment are wondering how to put their own architecture in place. And the question is there a playbook to draw on?
No, in a word, I'd say
I was going to say the same thing.
There really isn't. I do think it's fair to say there are definitely structures that we've relied upon. I mean, I think, again, I'll point to security as a great example where I think 10 years ago, maybe folks were sort of in a similar state of just controlled panic, if you will, to figure out when and how to deal with some of these adversarial challenges. And not that issue is solved, but I think in comparison, it's one where you do have an effective framework that's developed over time just through experience. That's not to say it's completely chaotic. One of the things I love about this space is that I actually get to spend a lot more of my time than I used to with our cutting edge researchers. And both because of the value of the education that I get in working with them and really learning more about how they address these issues, but there's also a sense of calm that comes with it, that I realize that, look, where we lawyers may dig into an issue like, what's the potential liability around a biased solution? Where might you be leading yourselves or your customers into violating anti-discrimination laws? Tends to cause some panic, especially when you don't fully understand the technology. And that's not to say that the researchers don't take those issues incredibly seriously, but I get a sense of calm from the perspective of researchers who have been looking at these issues really for quite some time, and who are very aware of the fact that we are in sort of a space of exponential change where this technology is out much more broadly, and yet they're bringing to it, I think, this rigor and discipline that comes out of the research focus to dealing with data in ways that they have really for quite some time. So long way of answering your question. There isn't a playbook yet. The playbook is evolving. I think the more we share the playbook with others in the industry and beyond, the better we all get, so that we all are working towards, I think, common playbooks. And I think, 5-10 years from now, we may look back and say, do you remember the days when it felt like the frontier? My guess is there will be, new elements to this frontier by then, but we will be in a space where we can look across and say, there have evolved much more effective ways for thinking about these sorts of issues and addressing them, throughout design and development.
It's interesting to me is like this is one of the spaces where I think large corporate incumbents have some advantages, right? One of them is resources, the ability to resource a lot of the work that you're talking about in implementing safeguards and thinking deeply about these issues. If you're a small startup with a really cool algorithm, you might not have this apparatus around the technology to try to protect against some of the harms that you listed, which I think are all very meaningful, right? So I think large incumbents have some advantages here that compensate for the usual disadvantages would be slow, and everybody knows the narrative about big companies. Two more points on the research side. I agree the most rewarding part of my job in the last 2 years has been working with the researchers and understanding their methodology, which is very different than the lawyers, right? We think about issues as, okay, that's a new development. What are the risks involved? I think, and we talked about this a few minutes ago before we started, one of the ways that I've learned to think about how the researchers think about the product development in AIs, it's a quality control issue. Like, if I've got an algorithm that has this bias, the first thing they think of is not what's the litigation risk, and they are really like, well, then it's a crappy algorithm, right? I didn't do a good job. And there's a lot of, that drives a lot of deep thinking, I think, amongst folks who really understand the technology much better than I do as an attorney, and most lawyers, I would say, that drives some of the quality control around the AI development. So it's interesting to watch the researchers and the scientists think about the same issue I'm thinking about from a different lens, and in some ways a more powerful one, which is their drive to make the best product possible, which means not creating some of the risk factors that then we worry about on the legal end.
And Jeff, please go ahead. Jump.
I was going to add. I was going to add to that. We talked a little bit about in this space the importance of bringing these very different disciplines together, so that lawyers, where we worry about certain sorts of issues, researchers may worry about different issues, ethicists and others may look at these from yet another angle. I do think one of the areas that to me is quite promising is actually I do feel like you're witnessing more of that coming together.
Yes.
So that these sorts of issues now are being thought of from these different angles, but being done collectively.
Yes.
So that what's being produced, again, to the extent there's a playbook evolving, it's a well-informed and richer sort of playbook.
Terrell, I get asked by clients frequently, and I'm sure you do as well. We want to start approaching these issues. What are your other clients doing? What is the playbook? What are you seeing out there?
Well, thank you for the question, and I'll just note that I'm been in the government for a really long time, so relatively new to the practice of law, and I don't have a ton of clients, but but I'm hoping to at some point, especially those thinking about these issues creatively. And I guess I just wanted to jump in into this conversation about playbook and is there one, to say I think there is the start of a playbook. And I think that's incredibly encouraging. One of the things that we've seen around this technology is an tremendous amount of civil society, academic, and industry effort around the questions of what are the guiding principles for development of this technology. And the good news is all of those efforts are underway. Many of them have been discussed this morning. A lot of them are really coalescing around some principles, okay? So we have principles. They include safety and security and privacy and reliability and accuracy, transparency, explainability, accountability, the trickiest in my view, fairness, right? Because wow, that's a big one. And so we have these big ideas about principles, and the challenge, of course, is, okay, how do you translate and incorporate those principles into what you're actually doing in your day-to-day life and in the products that you're developing? And there I actually reach into some of the analogous frameworks that have evolved over time. And I'm really happy that Mike raised security, because I do think that's very analogous. Privacy by design was trashed a little bit earlier on a panel. I'm going to stick up for it for a second. I agree it's not been a total solution, but the origin of the concept of privacy by design, which was really proposed in around 2012 by a former privacy commissioner from Ontario, is the idea that, okay, we have these fair information privacy principles and practices that are all these highfalutin principles. How do we really translate that organizationally? So it's a very process-based, design-oriented approach to privacy. The FTC picks up that concept. It now, as an agency, promotes that as a good approach to privacy practice. And over time, what you see is the FTC also picks up that approach, and so does the security industry, to data security and cybersecurity challenges. And they talk about security by design. Again, very process-oriented approach, because what is recognized in all of these approaches is that it's a very dynamic space that's evolving very rapidly. So I think of this as those methods is actually very translatable. And I like to think of governance by design as the framework that we are actually aiming towards and should be talking about in this conversation. So I'll
Literally
leave
just
it there.
wrote those words down.
Oh,
Literally just wrote
cool,
those down.
Jeff. Maybe you should jump in then.
Jeff, I'd actually love to pivot a little bit with you and ask from your perspective. We've been talking mostly about self-governance here, and self-governance with an eye towards law and regulation. But I guess that raises the question of two things. Are existing laws sufficient to mitigate the risks around AI? And importantly, because often overlooked by lawyers, are existing laws sufficient to bolster the development of productive AI?
So this is a little bit of a technical term, but hell no to your first question. I don't think they're sufficient. But I also think that when we jump to discussions like the last panel, like an FDA for algorithms, it kind of makes me shiver. I think very much what Pedro was talking about, you got to we've had this technology for a long time. We got to understand which networks we're using, which algorithms. Convolutional neural networks are very different than, others. So we need to understand at some level what's going on with the technology, and we need to understand the context in which it's being used, right, for every single one. So I will start by saying, no, our laws are not sufficient, and then I'll quickly say, but that does not mean that we go to this switch on and off. I love Mike's word, muscle. Muscle seems like such a great word. For me, you used two words that stuck out for me, Mike. One is we need to develop this muscle on how to deal with these issues, and then you also used humility, and I like that because somebody with these muscles has always had to have humility. So I really like that idea that we need to think of it as a process and like this governance by design process. I think a good example maybe about, do we have the right laws? Amanda on the first panel mentioned she was very humble and was referring people to other articles, but people should read her article on low friction data and specifically the way that the fair use doctrine could be used, expanded, et cetera, in order to help create higher quality data. That's such a great example on the opposite side of the FDA for algorithms spectrum, where you say, here's a very specific issue with data that we're seeing. Here's not only a law, but a subpart of a set of laws that we can look at in a careful way and say, how can we reshape this in order to accomplish better ends? If we're having the kinds of discussions with companies who are developing algorithms, they're going to be the key players. If we're having those discussions with really smart people like Amanda and helping to shape the doctrine around those, and the government is learning from them, and our legislators are learning from them, we have a process that we can do to not turn on the lever of FDA for algorithms, but to reshape existing laws in some ways to really accomplish, I think, positive ends. So that's to say, no, I said hell no, actually. I don't think we're there. But I also think that it doesn't mean that we drastically jump to the end where we have this big daddy who says, yes, thumbs up, thumbs down to all algorithms. I think we're not there. So.
Terrell, we have the Federal Trade Commission Act, which is a general enforcement authority to require companies to follow fair and truthful trade practices. Is that going to be a useful framework for governing corporate activity in the AI space? Do you think more or less would be needed? Do you see more space in industry verticals and industry-specific regulation, or more of a federal overarching framework?
Well, so I want to pick up on a point Jeff just made and answer your question, which I think I can do. Which is to say, the idea of one-size-fits-all regulatory solutions strikes me as wrong. because of the variation of the technology that we're talking about. So I do get a little bit concerned when I hear, one proposal will address the use of algorithm. I mean, what? I think we have to understand what the technology is doing and how it works in order to make the right policy around it. So what's been useful about the Federal Trade Commission and the Federal Trade Commission Act over the last 104 years has been that it is actually very broad authority to protect consumers from unfair, deceptive acts and practices and unfair competition. And over time, it's iterated on what that actually means, and it applies a standard familiar to the lawyers in the room, right, of reasonableness. That's a fairly flexible standard. It allows it to keep pace with a lot of change in the economy over time. Now, of course, one of the hot debates in policy, in privacy policy especially, but more broadly in other policy areas in Washington at the moment and really around the country and I guess globally, is whether that kind of agency with that kind of authority has sufficiently kept pace with the technology. I think that's a worthwhile conversation to have, certainly being had across the board. But I will point out that it is a framework that has been able to keep pace to a certain extent, while also being relatively technology neutral. And I think it's no accident that using that framework, the FTC has really identified ideas of privacy by design and security by design as useful methods to try to address some of these issues, and useful ways to encourage self-governance as well. So I think it's relevant, and I think we're going to see the FTC continuing to take an interest in these areas. In the previous panel, there was also a lot of discussion of some of the other legal frameworks that also may be applicable, especially civil rights, anti-discrimination protections, equal opportunity, access to housing. So there are other legal frameworks outside of consumer protection that are very relevant. And of course, the FTC has flagged that as well in previous reports. The big data report from 2014, for example, identifies some of those other legal frameworks as potentially relevant, again, depending on the technology.
When the World Wide Web was really coming into prominence in the 90s, internet companies pushed very hard for legislation, eventually resulting in the Communications Decency Act, saying, look, if you want to encourage active consumer participation and all these great network effects, you need to immunize internet platforms for the content that that some users may put up. We need that to grow the model. We can't operate and bring the innovation under that cloud of potential liability for what millions or billions of users that we don't really know might do on the platform. And they got that legislation. For Pedro and Mike, do you guys have a legislative or regulatory wish list? In that way, is there, usually the attention is, oh, we don't want regulation, right? Is there anything that could help?
Okay. Well, first I'll say not in the same way, at least I don't think so yet. So in other words, as you point out, sort of Section 230 and the need to immunize platform providers from liability for defamation or libel or for intellectual property issues, I don't see the same dynamic quite yet. There is, I think, a conversation out there about whether or not it would be helpful to have some sort of proclamation, some sort of safe harbor, if you will, for certain sorts of instances or events. And I at least speaking for Microsoft, we're not at that point yet. Having said that, I think there are a couple of things that we have been saying generally about this regulatory question. Is there a need to regulate? On the one hand, I think we would argue there shouldn't be a rush to regulate. As this whole conversation has illustrated, I don't think any of us yet feels like we fully understand the technology, the implications of the technology, the trade-offs between the benefits, potential harms. None of us knows that well enough, and I don't know that we ever will, to get to a point, as Jeff suggested, that we'd have like an FTA to oversee all of these sorts of issues. So the call there has been to be patient, be careful, to be very engaged, so that industry and civil society and government should be having very open dialogue, sharing information about what's happening, what we're learning, the fact that we are learning a lot as we go. That dialogue should be happening, and we should be patient before we rush to regulation. Having said that, there may be certain specific uses or certain sectors where there is a perceived gap and there is an acute need perhaps to move more quickly. I think people are worried that certain things will get out of the box and it'll be impossible to put the genie back in the bottle. And the one area I can think of today where I know there is, I think, a more specific call for regulation is in the area of facial recognition and the potential to use that technology to individually identify persons in public spaces in particular, but also to use it for ongoing surveillance. I think there's enough of a debate, there is enough concern over the impact of that sort of technology on disadvantaged communities, and a sense that again, with certain technologies being out there in the wild already, we do feel like we're at a point where it would be better if legislatures got involved sooner. So I think you may continue to see those sorts of examples where there may be specific use cases where at least we would feel like we would all be better served, society at large, by the democratic process moving more quickly.
Yeah, I think there's look, I'll speak for myself, not Oracle, on this issue, but I don't know that rushing to regulation, specifically in the way you framed it, which is this, some kind of governing body that oversees everything, is going to be particularly helpful or productive. And so, to your point, I think we're still kind of in the discovery phase of trying to figure out, how best to approach governance generally around AI and automated decision making. But there are some things that stand out to me specifically that I think I won't advocate for law, but I think eventually will get regulated. One is like transparency, right? Having people know when computers are making decisions about them, I think is something that eventually will become law somehow, and be enforceable. Meaning there will be some duty to notify people that machines are making decisions that have impact on them. And it might be sectoral, it might be about healthcare, or it might be about finances or whatever, employment. But I think there will be some sort of push in that direction by civil society specifically. I also think there will be a push to allow people to know what decisions are being made. So decisions are being made by computers. Here's what they are. There's a lot of talk in Europe about how GDPR is going to fit in an AI context, and a lot of the discussion is about algorithmic transparency. Well, I asked a follow-up question to that, which is, well, how valuable is that to a consumer, right? And I think about my mom, like telling her, here's a math formula that decided you're not qualified for a mortgage. Here's the formula, Mom. Like, that's not going to help her think through what the impact of that is. So what we're being transparent about is going to have to be something we think about. And I think it'll probably generally be, there was an automated means to make a decision about your financial situation. Here are the factors that were used, and here's how the machine came to this outcome. And then I think the follow-up to that will be some regulation around appealing that decision, right? Being able, as a consumer, to have some right to challenge the decision that the machine made based on the factors it made or the factors that it didn't use or the mischaracterization of those. There could be, false positives in the data, all kinds of reasons why you might want to challenge the decision. One of them being, I just don't want a machine making a decision. So I think there will be some regulation around that. And then let's talk about deregulation for a second. And you talked about Amanda's article, which I love, and I shared with my whole team as we think about accessing the best data to train models, right? There are a lot of legal barriers to good data. Paywalls, copyright, and a bunch of others, right? How do we get rid of some of those barriers or minimize some of those barriers to ensure that when we're training models for automated decision making, that we're giving them access to the best available data, not just the cheap data or free data that might be filled with all sorts of bias and challenges. So that's kind of how I think about it. Some regulation in some areas is probably forthcoming, and then some deregulation, particularly around data access to the best information possible, is probably something we'll see.
Can I make a plug for just a relatively easy set of ideas that I think is actually getting a lot of attention in Washington, as it should, that would be a pretty good place to start, in my view, which is making sure the existing government agencies that are actively looking at a variety of these issues, because the FDA is, the Consumer Product Safety Commission is, the FTC is, the FCC is. There is actually the alphabet soup kind of already engaged around these questions. Oh, right, the FAA, NHTSA, right? Making sure those agencies are properly resourced and making sure that both Congress and those agencies have the technological expertise or access to it. They don't have to have it all in-house, but they need to be able to bring in experts when they need to to really be understanding the technology and how it works and the implications of how they're using their authorities. So I think there are places we can start to make some improvements relatively quickly that are not even that controversial, as we also understand the implications of the technology.
Let's talk about the global landscape for a minute. In some areas of technology law, we're starting to see a splintering of regulatory approaches. So I do a lot of work in the data protection space. You now have the U.S. at the federal level taking a pretty laissez-faire approach. There's not new legislation, privacy or cybersecurity at the federal overarching level. The European Union has taken sort of the exact opposite approach, this sort of supranational, very prescriptive privacy framework, the General Data Protection Regulation governing 27 countries. China has passed its own legal regime that is in part about data protection in the way that we think about it, and in part about sort of maintaining cyber sovereignty. And it's creating a real headache for a lot of companies that operate on a global basis of how do you companies don't do research and development and product development on a siloed national basis, and they want to move product and service to many markets, and it's getting really hard in data protection. And as we're sort of at a much earlier stage in discussions about possible AI regulation, do you guys see, to any of the panelists, any countries pulling ahead faster than others in trying to insert themselves into this space from a regulatory perspective?
This is one of my favorite topics, and if we're talking about AI specifically and China, I think China has some pretty big advantages in AI development and doing it rapidly and at scale versus like the U.S. System, right, which is very non-centralized, very private, corporate-driven. Most of the investment is happening in the private sector. I mean, the U.S. government makes some investments, but it's really, like you said, very laissez-faire about AI so far. I mean, the Obama administration put out, I don't remember what it was called, like the AI guidance or whatever it was, which landed and then kind of fell flat after some Donald Trump news that hit that same weekend, right?
Thanks, I worked on that.
Yeah, it was great. It was great. And then there was a bus incident with President Trump that took over the discussion, I think, that same weekend. But with that being said, I think the Chinese have some advantages, and I'll tell you what I think they are. One, it's a directive economy, it's a directive system, and the Chinese government is playing a very active role in trying to get the private sector in China to have access to as much data as possible, and they can direct it, right? Like the Chinese government can say, here's a pile of data that we collected from all these sensors all across China, or from whatever, healthcare systems in China, or whatever it is. We don't have that system here. So I talked about access to the best data a few minutes ago. I think in China that's a tremendous advantage. And then the other one is massive investment by the government in China, right? The Chinese want to win in AI development, and part of their strategy is to pour money and investment and resources into it. I don't see that level of activity in the United States. So if it's a competitive, process between the two countries, I think we have some disadvantages there. And then the balkanization of regulation, right? These pockets of different regulatory frameworks will further limit other countries outside of China's ability to do this. I mean, I think China is like 1/7 of the population of the world. So if they have free access to all of that data, that's going to give them an advantage. Where everywhere else, you've got these so do American companies use European data? Who knows, right? GDPR has complicated that a little bit. Do we use data from countries in Asia? It's complicated because of the Chinese influence in those countries. Do we use Latin American data? What's the quality of that data? There's a lot of questions.
It seems that there's two ways that a government can insert themselves, generally speaking. One is to regulate. People think of that as the brakes. The other is to inspire and innovation, and the gas in the way. And part of what Peter's talking about is the gas, right? So China has been doing all sorts of things to inspire a catching up, right? So when it comes to entering, just back to your question, when it comes to entering in to regulate, there aren't that many countries who have very productive AI research systems. And so it's hard to look around and see anybody who we could look to as fellows in that area. China is one of the only countries. I would point out the UK's House of Lords report which came out just a little bit after Terrell's report came out. It was actually quite good, and it was from an unexpected place, the House of Lords and AI, right? I mean, it just didn't seem like it was going to come from there, but that was quite good on identifying some of the issues. And what I really liked about the report is their list of those with whom they spoke, and it showed a very productive conversation going on, I think, with industry and the government. And Mike said this about the open dialogue. I think this is really important. If you don't mind, I want to merge this question with the last one, though, because I also don't want to let our private companies let themselves off the hook too easily, which if we stopped the conversation right now, I would say we have, actually. So I would go a little bit further with the self-governance discussion. And actually, maybe, I think Kathy O'Neill said this in her own words earlier, I actually think we have the incentives and disincentives set up in a way where there's no win on this, to be honest. I think a couple of things. Private companies are going to be the leaders in this. We can see from innovation policy perspective, it's not government investment, it's private investment. That's where all the knowledge base is, et cetera. That's far exceeding our cultural awareness. So the primary brakes on a self-governance system is consumer demand and consumer, but our consumers, we can ask anybody, let's do a Jay Leno on the street. Nobody knows anything about algorithms, right? Especially the ones that are behind the scenes, B2B, et cetera. So we don't have that. And then if you think of any situation, whether it's giving up a data set that can't be unbiased, or it's some fundamental science that Google DeepMind researchers are putting out that we understand could fall into the wrong hands and quickly be used to decimate the world, under a shareholder supremacy model, that's never going to stop. Right? That's never going to be stopped. It's just not. I mean, there may be an instance that you can point to, but the overall outcome under that model is that it's not. So if we keep in-house under a for-profit company structure our ethics and society boards, I would argue that we're doomed a little bit. And so I want to be a little bit of a naysayer there on the self-governance issue. I don't think that means we're doomed, though. Actually, even though I'm from Chicago, where a fire burned down the whole city, I actually think fire is one of those things like that we will look back and say, I can't believe that AI is like fire. Excuse me, I can't believe we ever lived without this. I am optimistic, but we're not going to get there in that model. And so I actually, with this discussion that I wanted to link, I think one of the problems with this discussion, before we go there, we had this discussion, when we say, China, though, will outpace us, one of the really dangerous and insidious things that does is it causes us to say, then we can't regulate, right? I mean, it's used as this trump card to say, but if we come down and try to do the right thing, we're going to lose out to China. And I think that's becoming a very dangerous part of our public discussion. And I want to make sure that we don't allow it to keep us from thoughtful people who care very much sitting around saying, we'll work with the government, we'll work with consumers, we'll educate the public, and we'll do the right things.
We've talked a little bit in bits and pieces about data protection, but let's take it square on. AI rides on data. It ingests and it spins off massive amounts of increasingly personal data. Is there hope for privacy in an era of AI, or is it a lost cause?
Okay, I'm going to be the hopeful one. Maybe Jeff will be the doom and
I'll
gloom one.
hold up that end of the bargain in just a second. So
Great, cool. Yes, of course there's hope for privacy, because I'll take issue with the question just a tiny bit, no offense.
Please.
Which is to say, when you're making generalized statements about AI and the data it's running on, you are falling into the trap of trying to generalize about technologies that are incredibly variable, that really requires some understanding of what they are actually doing and how they're being trained, what data they even need to be trained on, right? Because that could be different depending on the kind of technology you're even talking about in an increasingly predictive or autonomous system. So I think we ought to be very careful about waving privacy around as being dead or being not a value that can be protected within proper governance frameworks around these technologies.
we immediately passing to the other end of the spectrum.
We are. Go ahead.
I really do actually totally agree with that. I just think that the fundamental technological tension that Terrell pointed out is, you need data in order to train these systems, and you need ongoing data in order to improve the systems. And so it's a hungry technology, and so we always need to provide it.
Can I circle back though for just a second too, because I think there's an important thing that has come out in the course of the morning that I found incredibly interesting, and I just want to observe it for a second, which is Mike, Pedro, I think Chris on the earlier panel, all identified zones in which the companies that are on the front lines of this technology are thinking about these issues and also issue spotting them and saying everybody ought to pay attention. Chris, I think, talked about video feeds and autonomous vehicles. You were mentioning facial recognition and some of the implications of that. And when we see them flagging those privacy concerns and those other concerns, I think that's actually very hopeful development.
Yeah, and I actually think the companies are real leaders here. I mean, companies have been self-identifying privacy issues. And every document that you read that comes from a company lists privacy, lists autonomy as a kind of ethical concern, human autonomy, et cetera, as one of the potential threats here. And companies are actually thinking about this and thinking about sharing data or different methods. I think we can learn a lot there. I really think the reason I'm pessimistic is because of me, right? Because of us, because of the consumers. I think the GDPR, which has been referenced many times, is not just a different law in kind of a top-down approach or a comprehensive approach to privacy. It's also a very philosophically different approach to privacy, and it's one that's really distant, I think, from the highly transactional nature of privacy here, where we say, I will click terms of service, give you this, and I have no expectation moving forward outside of the FTC kind of unfair, deceptive trade practices. Did you do with my data as you said you would? The GDPR, with the right to be forgotten and the right to data portability, et cetera, creates an ongoing relationship between the data providers and the data hosts or processors that's a lot closer to a human right. It's a recognition that data has something to do with identity and self and autonomy. And if you're from a system like Germany, for instance, that obviously had autonomy issues that at a point in time, and privacy was used to not only harm people in terms of directing their advertising, but literally kill people. You have a different approach to thinking about what privacy is. And I look around and I include myself in this group and think of all ways I give up data, and I just don't see us getting there, right? And so I think companies have actually been both good and bad players, but at least in their disclosure. Actually, let me point this out. Microsoft is one of my primary nitpicks in this area. They had a great document that came out on AI ethics. In about the same month during the Super Bowl, had a rapper say the words "AI is magic," and about 10 people who I know read the report, and about 10 billion people. It seems like there's not that many people, but saw the commercial, and I think that undermines what we're trying to do, which is get the public to be on guard against this. I think the public message around AI convenience, et cetera, is way too strong. We're not going to pull back from sharing our information, and I think that we're going to have a very different conception of privacy moving forward. We're almost beyond the point of no return.
Pedro, you have both AI and data protection under your portfolio. How do you get engineers to think about privacy law as they do their work and development? What are the guardrails, and do you feel like is there a feeling that privacy law is impeding the development of artificial intelligence?
I mean, you're always going to get that feedback from product and specifically salespeople, but product folks are always going to say, get these laws out of my way. I've got all this cool stuff I want to build, and people are going to be enriched by it. Yeah. It's going to be great, right? I put something posted something to LinkedIn and Twitter the other day. If you want to be friends on the internet, let's do it. But it was Dr. Ian Malcolm, so Jeff Goldblum from Jurassic Park, right? One of his lines in the movie, and I'm going to paraphrase it because I don't remember the specifics, but he said, the scientists are so busy thinking about what they can do, they haven't thought enough about whether they should do it, right? And so that's where I think the lawyers come in, and you guys talked about ethicists and folks with duties that go beyond just creating the best product, right, as part of their responsibilities, injecting some of that type of thinking into the development process itself. And how you do it's going to vary from company to company, I think. My approach in running my group is very much embed in the development work and be a resource and a sounding board for engineers, not so much coming in on the back end after they've spent 2 years developing something, and then you say, nope, you got to strip all the social security numbers out of there. Getting involved early helps them think through some of this stuff. You talked about privacy by design. You can help them implement it because you as a lawyer or as a privacy professional, you're thinking about those issues in just I don't want to say more nuanced way, but with a different nuance than they would. So being involved matters. How that looks is going to vary, I think, from company to company. But getting in the mix, getting your hands dirty, taking off the lawyer white gloves, and really going in there with dev folks doing dev work on the ground, I think pays dividends. That's kind of my
Yeah, absolutely. Completely agree with that, Pedro. And in fact, I mean, this has actually been an area where I do think privacy law, to the extent it is evolving, has actually produced better outcomes.
Mm-hmm.
And in a way, the dynamic is not unlike what we're seeing with issues like fairness and issues like intelligibility. The people working on these issues, at least that I encounter, take these incredibly seriously, in part because it does lead to building better products, but I think in large part as well because these are individuals as well. We're all sort of in this space now, as you're suggesting, Jeff, where we're leaving a digital footprint on a daily basis that I don't think any of us really truly understands, and we're the folks who actually do this stuff on a daily basis. And I think the people who are doing this work understand that look, this comes with tremendous responsibility. And so to the degree that GDPR is driving companies to think about how would you disclose the logic of decision making, how do you even understand what that means, it's driving really positive, impactful activity to think through, okay, I'm going to design a system that then I have to be able to disclose and understand. And that doesn't just mean throwing out the source code for someone's mom to look at. It's actually producing contextual, meaningful explanations for the behavior. And so what I've at least witnessed is there's this energy to tackling these sorts of problems because they are so real and people take them seriously. And in that regard, I would say what we're seeing out there in the regulatory space has actually been driving better results.
We've been talking about guardrails and regulation on companies. Let's look at the other side of the coin. Terrell, the FTC is the consumer rights watchdog agency of the federal government. What rights do consumers have? Are they invested with rights with respect to use of artificial intelligence by them, on them, about them?
Okay, well, thanks for the easy question. We've already been unpacking a little bit some of the differences between the more rights-oriented approach to data privacy that exists in the GDPR and some of the frameworks that are being adopted that are very similar to that versus the existing framework in the United States around data privacy, which is more reliant on the traditional consumer protection mandate to protect consumers from being deceived and making sure that they aren't being injured in a way that they couldn't otherwise avoid, which is basically the unfairness standard. And I think that in general, that is the kind of core basis of consumer rights, both at the state level and at the federal level, a right to not be deceived, or in other words, a right to have clear information about what's happening to you in the marketplace. And this involves very frequently information about what you're buying, information about how you're being advertised to, also information about how your information is being used, right? So that's where we see it come together around algorithms, actually in all of those different ways, because algorithms can be affecting any of those things. And then we see a broader use of the unfairness authority, especially by the FTC, primarily in the data security cases, but sometimes reaching actual unfair uses of information as well. And that's evolving over time. So if there are rights, I would say those are the rights. There is, I think, at this point, a right to reasonable security around your data based on the FTC enforcement, a right to have choices around how your sensitive data is collected and used. I think that exists following on the FTC mandate as well. And increasingly we're seeing a lot of discussion around whether the consumer rights in the United States ought to be expanded to include things like portability and access and correction and deletion. In the policy conversation right now around whether there ought to be a federal privacy law, for example, a lot of those concepts are being incorporated. And frankly, a lot of them are being proposed on a bipartisan basis by industry groups, by companies, and by consumer groups as well. So there's actually a lot of I think a lot of consensus emerging around expanding a little bit the consumer rights and the consumer protection framework around some of these issues.
And consumers have power. I mean, I think you talked about some of the limits of the power, right? Which is just not lack of awareness is one of them. But this is a law school. I mean, a law student in Europe changed everything all by himself, right? After having a meeting, after I guess someone from Facebook came and spoke to his class while he was in school. So, activism, individual activism, is a powerful force. There's evidence for it, and I think we'll see more of that.
That's a really great point. I would love to just jump in on that because it's come up already. I think, Jeff, you raised the idea of trust. Consumer trust is obviously fundamental to demand and adoption of new technologies. The FTC got into the business of being a consumer protection regulator that was handling privacy, for example, because it was worried about whether people trusted buying stuff on the World Wide Web. And so I think there's the legal risk conversation we've been having and how to mitigate that. But alongside that, there's the reputational risk conversation. And that is actually sometimes even more powerful because we see very clearly when people suddenly understand a use of their information that they did not anticipate, that can come with a huge consequence that's frankly more costly than some of the legal risks associated with it.
Can I make one more around rights? I mean, so I think where there's limitation in rights, it's not a failure of providing those rights. Sometimes it's just that it's really hard to do, and it wouldn't be appropriate. It might stifle innovation. There's all sorts of reasons sometimes we don't. I actually just wanted to point out one other role that I think companies need to play, which is providing tools to consumers to help them navigate these. So an example might be, and this goes back, Rob Ferris on an earlier panel does a lot with disinformation, new generative systems of AI, which we've talked mostly about discriminative systems or classifying systems, but generative systems are producing digital artifacts that are immediately understandable by humans and quite deceptive, right? You could imagine that we need the Microsofts of the world to help us develop tools as consumers that we may pay for, that may be a service they provide, whatever it is, to help us navigate that world. So I think on top of this notion that we're sending out technologies that can be potentially harmful, we also need to remember the role that the leading companies need to play in providing tools to consumers here, and the role of the regulators to help them build those tools that help address what we foresee as potential issues. So the disinformation issue is a really important one, and we're not going to navigate that one just with a technological solution. There needs to be cultural awareness, all sorts of other things, but we're also not going to navigate it without the technological solution, and we need the private companies to be helping us with that.
Yeah, I actually totally agree with you, Jeff. I mean, it's a great point. I think and it's not just the consumers, but it's the developer ecosystem as well, right? I mean, as part of the thrust, I think, is ensuring that these sorts of technologies are broadly available. What does that mean? Is it, hey, great, you've made facial recognition available to the world, and now you've turned it loose, and what is it going to wreak havoc? Just as important, and I think I see just as much dedication to doing exactly what you described, which is, hey, now that you're starting to figure out the issues and the problems, how do you share that learning? And not just in the sense of, okay, look, this is what I experienced, this is what I think this should be used for, this is where I think it's not sufficiently tested or ready. Those are all conversations that I think we should be having. We should be very transparent about what the technology should and shouldn't do. At the same time, to the extent we build our own tools to address these sorts of issues, those tools are things that we want to turn around and share out as well. Probably in the early going, more with a view towards the developer community, so that as these things are out there and as we develop tools for helping to find, for example, blind spots in data sets, or outcomes from certain data used and deployed in certain ways that were unexpected. All of that information, I think, and all of those sorts of tools are things that I think the industry should be putting out there and sharing. And I think there's reason for optimism, because so far I do think that's the way I believe the industry is beginning to address these sorts of issues.
I was on a panel recently with Kristen Goodwin, who's Mike's colleague at Microsoft. She's the lead cybersecurity counsel at Microsoft. She made a very interesting observation that when it comes to cybersecurity, we've seen an evolution of the threat landscape from threats predominantly around stealing data or stealing money to threats that have grown more sophisticated and are really about undermining the integrity of processes. A key example being use of hacking techniques in the 2016 election cycle to influence the outcome of an electoral process, for example. When you think about AI, and as you think about AI being deployed more widely in more critical applications, having more critical impacts on people's lives, you start to think about possible corruption of AI-driven decisions and really the personally catastrophic consequences that could have, and maybe without people even realizing it because of the difficulty of sometimes understanding algorithmic decision making. What obligation do companies have to ensure that they have quality control and security control around their algorithmic decision making to ensure the integrity of the AI?
A lot. Yeah, I think a lot. It's like any other technology that has meaningful impact. I think the duty to ensure its integrity will be one that companies will have to undertake. I mean, Volvo is working on their autonomous vehicle technology, right? Which is an AI technology. And there's an entire theoretical, like legal discussion taking place about how liability norms around vehicles are going to be applied in an autonomous vehicle ecosystem or in a mixed ecosystem that has autonomous vehicles and people driving cars, whatever. Volvo took the bold position, which is, look, we're going to stand behind our technology, and if it causes an issue, an accident, or an incident that creates liability or harm, we're going to be responsible for it. And I think the market is a factor in Volvo's decision, right? Which is, well, nobody's going to buy this thing if we're not standing behind it. And I think that will drive a lot of thinking in the enterprise, right? As you're automating processes, as you're deploying AI in your either B2B solutions or B2C solutions, while there's a theoretical discussion taking place about how old laws will be applied, I think some companies will just step up and say, hey, you know what, we're going to take the liability here because we want you to buy our products and we think they're good.
So I'm going to ask one last question before we go to Q&A, and I'm going to use my moderator's prerogative for the last question to pit all my panelists against each other. AI, it's obviously incredibly data intensive, and big companies have more data. Gives them a strong competitive advantage. I want to first ask Jeff, who presides over a startup accelerator at Duke, to talk about how are small startups ever going to be able to compete. I want to ask the representatives from our two corporate behemoths to talk about their view on the question. And then I want to have Terrell conclude, having formerly served as a commissioner of the FTC, which is the civil competition law enforcement authority in the United States, about how do we ensure a competitive landscape. Jeff.
So that's a great question, and I think maybe what I would suggest is that for public discussion purposes, we might reframe just the terminology, and I like to think of digital infrastructure. And I think data is one of the, if not a key component of digital infrastructure. And if we care about innovation environments, we need to create structures that allow even the insurgent players to have access that's maybe not totally on par with, but at least competitive with incumbent players. And so, one, I think this is not completely, David versus Goliath. It's not insurgents versus incumbents. I think actually a lot of incumbents want insurgents to have access to tools because that's actually a lot of their innovation structure is not in-house. It's through swooping up outside companies. DeepMind was purchased by Google, right? It was, and so it's actually in their interest as a company that serves lots of different markets, et cetera, to have an innovation environment that they can have access to. So I think there's some incentive already to share data. But I also think we could create new structures. So, for instance, a grant-funded project that I'm working on right now is around using trust, your old school legal trusts to house data. And are there ways that we could allow people, various actors access to that information with less concern about the negative implications for the beneficiaries of that, so the people whose data it is? I think we can start to get creative about creating new digital infrastructures that can assist nonprofit groups, that can assist startup companies like the ones we have in the accelerator, et cetera, and without doing that by coming down too hard on the big companies of the world who also need that data. So I think there's some hope there.
Yeah, look, I'll agree with that. And in fact, I like the term digital infrastructure. I mean, I think at one level, if you go back to the importance of developing trust in the technology and promoting this trustworthy narrative, I do think it centers around, continuing to explore ways to ensure that we all have more and better access to better data. It is interesting that in some ways it seems like this debate sometimes starts to rat hole into a conversation about whether, should Facebook be obligated to disclose or share data about its user behavior. And I think that is actually a bit of a sideshow to the conversation. I think, look, data comes in lots of different forms and from lots of sources. And again, look at the studies about the amount of data that's out there. We all talk about the fact that it's the amount of data that's driving all this innovation. In some ways, I don't know that there's really necessarily a shortage of data. And if one entity has access to data, it's not as if, a barrel of oil, it's used up. That same data should and could be available to others. So setting aside for a moment sort of the debate over, proprietary databases created by user behavior, but instead going at where can we just do more to develop that infrastructure, whether it's helping to governments to make more of their data usable. Someone earlier, I think, made the point that, look, creating usable, well-documented data sets is not cheap. And so part of the battle, I think, for small and big companies alike is bringing enough resources to bear to make that data usable. What an opportunity for industry and government to get together and say, we've got these just collections of data that today may not be well positioned to be reasoned over by machine learning systems, but we could get there. And so I think, joint work and investment in this space by government and industry holds a lot of promise. I also think, much as people are looking and continuing to innovate, a lot of the innovation is happening around these infrastructure components like data pooling and encryption, where you could enable different players to reason over data without having to disclose the individual instances, without necessarily jeopardizing privacy interests or even trade secret or proprietary rights. So I think there will be continued investment to bring that sort of infrastructure to bear. My sense is that, again, industry really shares that objective, that the better we can do and the more we can do to create that infrastructure, the better off everyone will be. Pedro?
Yeah, I think I'll challenge something you said a little bit, which is, the big incumbents have access to the most data and there's an advantage there. And I think, yes, there's some advantages. But there are a lot of challenges, right? And I'll list off a couple. A lot of the data that big incumbent companies that have been around a long time have is, the usage of that data is limited by contract with their customers, right? So just because the data is sitting in the vault doesn't mean you can necessarily apply these use cases to that data. So there's an entire legal process that has to take place to enable that if you're going to do it in a responsible way, which is tedious and slow, and it requires an education and a raising of awareness amongst customers about how using that data in the aggregate will generally improve their overall experience with whatever. So there are some contractual barriers that limit data that you have access to that exist, I think, that incumbents have to face that maybe, up-and-coming startups can account for upfront and not have to go backwards, which is much more difficult to do. And then I think there's some legal complexities, right? So you've got all of this data that you can get all of this great signal and insight from, but it's personal data, and you don't have consent for the use case that you want. You have consent for these other use cases. So you now got to go through another legal process to get a permission to use the data that you may have access to for these new additional use cases. So I think incumbents have some challenges. I'm not to say that they're at this huge disadvantage, but it's not as easy as we've got the data already, flip the switch, right? I think there's a lot of process and procedure that has to take place to do it in a responsible way. And some startups might have some advantages there due to the fact that they're new to the market and can frame their governance around the ability to turn use cases on and off in a more agile way than I think companies that have been around a lot longer maybe weren't accounting for historically.
Terrell, you want to close this out before a couple questions?
I guess I just speak from the former competition enforcement perspective to say, first of all, the idea of data, very, very large amounts of it, is not a new thing for competition enforcers or antitrust law. So it isn't a new concept, nor is size a new concept. The competition laws and the antitrust enforcement agencies around the world have wrestled with these issues. And so they've, I think, quite appropriately, generally focused on the facts, which actually are very meaningful. And they've carefully analyzed, okay, well, is data a barrier to entry? Is there something about it in the market that we're looking at, or if in the competition that we're assessing in this marketplace, that is different than just sort of non-rival risks like data that's ubiquitous, that's everywhere, that's more like user data. And sometimes the competition agencies have found that data can be proprietary. It's usually not the consumer data that we're all shedding thousands of bits of every moment of our waking lives at this point. It's usually something more specific, like in the situation of Nielsen and Arbitron, a merger. It was data that comes about viewing information coming from set-top boxes on televisions. It was hard to get otherwise. So they look at whether it's proprietary, whether there's limited access to it, whether there's something about the data that makes it competitively significant. And I think that's actually appropriate because, of course, what we want from a competition perspective is for Jeff's startup incubators and insurgents to be able to enter. That's good competition policy. That's good innovation policy. And so I don't know that I have found in the course of the conversation that antitrust enforcement agencies are having, or even as an antitrust enforcer, that the antitrust law was incapable of analyzing the significance of data, nor have I found that just a very large amount of data was particularly competitively significant in and of itself. That idea is under debate. We have seen some competition enforcers lately, mostly in other jurisdictions, not in the US, mention the idea of access to data for training AI systems as something that might be of interest to them. So we'll have to see how that space evolves.
We have 5 minutes. Are there any questions from the audience? Please.
Hi, my name is Mona Sloan. I'm a sociologist from the London School of Economics. I'm here at the IPK at NYU. I want to push back a little bit on the notion of betterment by design because I do research design inequality. And I wonder, from a legal point of view, how are you going to change a system that is profoundly unequal because it perpetuates historic inequalities? How can you tackle that when the burden of flagging the issues that we're seeing, the violence that we're seeing through algorithms, falls so heavily onto those who are affected by it, who have to go to court, who have to walk out on Google, 20,000 people, and make the case that there is an issue? How can you change that and not fall back on a sort of solutionism by which you just create more machines, which is actually something that a lot of tech firms are working on?
Jeff.
Can I? So I think that's a really good question. I like actually the use of the word violence because I think Kate Crawford, who does some work with Microsoft and others, has used this with prison recidivism algorithms and has said, don't focus on solving this technologically to the exclusion of the violence of the system, right? That puts more African Americans behind bars, et cetera, et cetera. I think it's a really good question. The one thing that I want to say, because I tend to be a little bit like Kathy O'Neill and sometimes be a little bit pessimistic. I don't have 4 categories of fear, but I do have general fear. But I do want to be a little optimistic, and that's that I think if played correctly, whether it's by design or whatever it is that elucidates the harms, it actually can cause us to better understand the harms that are existent in society anyway. So we're going to have Loomis discussion coming up, right? Where we focus on prison recidivism algorithms and the biases that are built in. Well, one thing that can help us to do is ask questions about judges that have long been biased for decades and generations, right? And maybe the optimistic way to look at it is that by doing these, it's not a perfect solution. It's a part of it. It could raise awareness and it can make us ask questions, better questions about the system as a whole, and identify and try to solve those violences.
Yeah, I agree with that. I think the question's an outstanding one, and I wholeheartedly agree with you, Jeff. The fact that these sort of implementations now are creating what I think is a broader dialogue about these sorts of issues, to me, is actually part of getting to the solution. I can't claim to tell you that I think there's a technological way to get at flagging or triggering these issues consistently enough that you would have the ability to ensure that those who are impacted have an obvious and safe way to raise concerns. But I do think the fact that these dialogues and these conversations are happening is maybe a path towards a broader, richer social dialogue on the very issues. Another great example, again, I raised it earlier, is facial recognition. I think the fact that you now have systems being deployed more broadly through a variety of different police forces, some of which put really no human oversight over the system, and some of which now are striving to do more of that. But still, I think raising some great questions about whether there's the potential for this technology to nevertheless continue to be most aggressively used in disadvantaged populations. That's a dialogue that I hadn't heard happening. It certainly wasn't happening within the tech industry to the degree that I think it is now. And in that sense, the fact that these questions are out there is very positive.
We have time for one more question. Please.
Hi, my name is Jay. I used to do marketing and PR for Microsoft, Intel, Ericsson. Now I'm with a nonprofit focused on sustainable development and specifically the use of data for sustainable development. I don't so much believe in the self-regulation approach. I don't think that's going to solve everything. So my question is a little bit more about a bit of what Terrell mentioned before about capacity in, for example, government. We don't have experts really in tech and such, and so you have a complete lack of understanding about how these platforms work. How do you incentivize, for example, law students, for example, data scientists to go into those kinds of roles when the money's not there, for example?
I think it's a great. I grew up in the cybersecurity field, that in which the government actually does loan repayment and things like that to attract workforce. At the FTC, we tried to take advantage of them because we found that the national security side of the government was excellent at doing that, and we thought the civil society side should be good too. So civil enforcement make a play for that. And I think the other answer to the question is, of course, it's hard to attract talent that's in demand, that's going to make more money in the private sector. But there are a lot of people who choose a life in government service because they find it fulfilling. So that exists, I think, is an answer to that question. And then lastly, I'd just add that sometimes the government brings in special employees or even hires outside experts. It needs the resources to contract to do that. And that's appropriate as well.
So please
Please thank me and join me in thanking the panel.